has 25 different books. And for those, some of the books, he has been recognized and given award. The Sahitya Academy Award, Pandit Govind Vallabh Pant Award. You know, it's absolutely amazing. As if writing 25 books was not enough. He has written 500 papers. What a rich contribution that he has made during his service journey as such. And besides that, he is an authority in the field of juvenile justice. Different aspects, he has marshaled them. He's up to date with regard to them as such. I many a time wonder, how does he find time for doing all this for that matter? Even after retirement, he is busy. He is on the visiting faculty regularly with the Chandigarh Judicial Academy. Also, HIPAA, many other institutions, including the Army Institute of Law, Mohali. And therefore, to have a resource person of this stature is certainly something which would enrich this particular session as such. We would start with Mr. B.S. Sarah, whom I had the pleasure of introducing in the morning session, and therefore, may I present to you Mr. Sarah for this particular session, and thereafter, K.P. Singh would take over. Thank you so much.
Thank you so much, sir. Thank you so much. I welcome Dr. K.P. Singh, my co-speaker, with whom I definitely have had the chances of interaction while my stint in the Chandigarh Judicial Academy. He has been our regular resource person for different topics. So this, I'll be just giving only an overview of different dispositional orders which are contemplated under the Act. The remaining part shall be covered by Sir only. So my part is only the introductory part. So far as the dispositional order is concerned, it is one of the very key stages in the adjudicatory processes stipulated under the Act, insofar as juvenile in conflict with law is concerned. Now, what kind of dispositional orders are contemplated and what factors are to be considered by the board while making a choice between among different dispositional orders. Section 18 contemplates that the board is required to bear in mind the nature of the offense, the specific need for supervision or intervention, circumstances which are brought out in the social investigation report, and the past conduct of the child. So while bearing in mind all these factors, the board is required to make a choice between different dispositional orders. Now, what kind of dispositional orders are available? We have advice and admonition. We have counseling sessions for the child, community service, which will instill a sense of responsibility in the child, payment of fine. Then we have non-institutional probation, that is probation where the child would be left or placed under the care of parents, guardian or fit person. Then we have institutional probation where the child would be placed under the care and supervision of any fit facility. Then we have institutional reformation available, whereby the board can direct the child to be sent to special home for a period not exceeding 3 years for providing reformative services. Apart from that, the section visualizes the passing of additional orders by the board depending upon the facts and circumstances of each case. But here I would add that the board would be guided throughout by the overarching principles which we all shared in the first session and the aim and object of the Act. So ultimately, this dispositional orders are intimately connected with Section 20 and other provisions of the Act. So what choice to make, how to make that choice, Dr. K.P. Singh would definitely elaborate and provide insights to all the stakeholders at the time of adjudicating these processes. But then Section 39, I would like to bring to the notice of all the stakeholders that Section 39 clearly says that the rehabilitation and social reintegration shall be undertaken on the basis of individual child care plan, because each individual who has come in conflict with law will have his own individual needs depending upon variable factors of the child, preferably through family-based care. So the principle which is there under Section 3, it is reflected in Section 39 that this processes must be undertaken through family-based care. Second is that in respect of children in conflict with law, the same shall be undertaken in the observation home, in the special home, or place of safety or fit facility or fit person. Again, all these are different child care institutions which have been established under the Act to provide correctional services to the child who has come in conflict with law. And the last principle is that institutional care is to be used as a last resort by the board or by the children court. Now, there are certain principles which have been evolved while making the choice. It's a risk principle that the board has to keep in mind the factor of the risk of reoffending, then need-based, in which they have to take care of the individual and environmental attributes of a child in question and lend him a helping hand to overcome and change those individual and environmental attributes. The last is the responsibility principle, in which the individual traits have to be built up. That is the capacity building measures which have to be taken up in respect of a child in order to facilitate that he is able to reform himself. So with this, I hand over the stage to Dr. K.P. Singh. He can take over the session and give his insights about making the choices in respect of different dispositional orders. Thank you so much, sir. Thank you.
Thank you, Baljinder. You have made my task easy. You have given a complete overview of what I'm going to cover in the session. When after Mahabharata, the Pandavas, they went to heaven one after the another, excluding Yudhishthir. They saw Duryodhan there. At this, Bhim was furious and he shouted, "What this Duryodhan is doing here?" And when the last Pandava, Yudhishthir along with his dog, reached heaven, they all gherowed Yudhishthir and asked, what was Duryodhan doing there? He should have been in hell. Yudhishthir replied, no. And he explained that whatever he did it was not because of his fault. It was because of his upbringing in his childhood. He was not brought up properly. He was given bad sanskaras. But he is here in the heaven for one reason only, because he pursued his aim, that is becoming the king of Hastinapur, with vigor. From this story, what I wanted to bring to you was the spirit of inquiry under JJ Act. Duryodhan could not be sent to hell because whatever he did, it was because of his sanskara during his juvenility. He could not be given proper sanskara by their parents, so he does not deserve the punishment in the hell, but rehabilitation in the heaven. And this is what the spirit of inquiry under JJ Act is. It is not another trial. It is a rehabilitation exercise. Therefore, shun the robe of a judge and be a foster parent. I always start this lecture with these few lines. And keeping in view these lines, the preamble of the JJ Act reads, to cater to basic needs of CCL and CNCP through proper care, protection, development, treatment, and social integration by adopting a child-friendly approach in the best interest of the child for their rehabilitation through processes provided. If we go through these words carefully, we will see that the word punishment or conviction is not there in the preamble. The importance is on rehabilitation. The importance is on child-friendly processes. The importance is on treatment, development, protection, and social reintegration. And this is what is expected of us when, as presiding officer or principal magistrate in the JJ board or presiding officer in the children court, follow the ideal words which have been spelled out in the preamble. Baljinder has mentioned about the common principle of juvenile justice, and in the morning you might have learned in detail about these principles. Here I would like to mention only 5 principles which are commonly ignored in our dispositional orders. And they are the principle of non-stigmatizing semantics, principle of best interest of child, principle of right to privacy and confidentiality, principle of diversion, and principle of fresh start. I will not go into the detail, but will mention only briefly what does these principles say. Principle of non-stigmatizing semantics is the most common principle which police as well as the other stakeholders are not following and blissfully ignoring. What does it mean? It means use of adversarial or accusatory words such as arrest, remand, accused, charge sheet, trial, prosecution, warrant, summons, conviction, inmate, delinquent, neglected, custody, or jail is prohibited in the processes pertaining to CCL. But still you will find all these words are being used by police in their investigation and later on by the presiding officers in their dispositional order. Principle of diversion entails that if we can deal a CCL without resorting to judicial proceedings, we should do that. I have the opportunity to go through almost 24 judicial orders under the JJ Act, and I could not come across even a single case where this principle has been followed. Principle of right to privacy and confidentiality. The identity of the CCL as well as the CNCP is not to be revealed throughout the judicial processes. But I could not find even a single judgment where the title was not with the name of the juvenile. This principle was ignored, and this principle entails that the identity of the child shall be hidden in the beginning itself on your Gemini file, and then in your dispositional order as well as in other proceedings. The name of the child or his address will not be mentioned. He will be addressed with that fictitious identity. Another principle is proceedings in camera. It is desirable that in all the dispositional orders, this fact should be mentioned that the proceedings were conducted in camera, especially when the proceedings are going on in the children court. The JJ board is not located in the judicial complex. There very little crowd may be there, but in children court, the court is full. The proceeding should be held in camera. Principle of fresh start, section 24, 1 and 2, entails that child shall not suffer disqualification because of conviction found on wrong side of law. Another principle entails destruction of record by police as well as by the court, except for CCL who is tried as an adult. Third thing is about safe custody of the judicial record for a period up to the time of appeal is over or up to the period of 7 years. Our judicial orders or dispositional orders should say something about all these things. But there has been some shortcoming on this aspect as well. Stating with these basic features which we have to pay attention, let me now discuss what are the dispositional orders which the presiding officers have to pass under the JJ Act. Firstly, by the JJ board. The JJ board has to pass dispositional order as preliminary assessment or dispositional order after due inquiry. The children court has to pass dispositional order firstly as JJ board under section 18 if the court decides so, and then as children court under section 19. So these are the dispositional orders which now I will discuss, and especially with reference to the components of these dispositional orders as well as the shortcomings in those dispositional orders. Preliminary assessment, we all know the purpose is to assess the mental and physical capacity, ability to understand consequences of crime and circumstances in which the crime was committed, and assistance of experienced psychologist or psychosocial worker may be taken by the presiding officer. And this preliminary assessment is to be completed within first 3 months of the first production of child before the presiding officer. In this preliminary assessment, I have listed here few steps which should be undertaken by the presiding officer. The first and the foremost step in the dispositional order is assigning fictitious identity to the child. The second step should be determination of age, because that is what will give you the jurisdiction. Third, determination of nature of offense, which will again decide your jurisdiction whether the inquiry is to be conducted by the JJ board or by the trial is to be conducted by the children court. Only after deciding or after mentioning these three things in the dispositional order, then we have to begin with the preliminary assessment proceedings. And in the preliminary assessment proceedings, first we have to call for record from CWPO within 1 month. Under the provisions, it is mandatory that the child welfare police officer will submit the basic record of the case before the JJ board within 1 month, so that the JJ board can start the exercise of preliminary assessment. Unfortunately, it is not happening in most of the cases. If the police or the CWPO is not forwarding that record, then the JJ board should call that record because it is their responsibility in heinous crime to conduct the preliminary assessment. Then after considering that record which has been forwarded by the CWPO, that is FIR, statement of witnesses, proof of age, etc., etc., the JJ board has to interact with the child, if need be, to assess themselves the mental, physical, and psychological status of that child. And they should take assistance of psychologists and other experts. Those psychologists and other experts are to be provided by DCPU, District Child Protection Unit. After that, the board should consider the social background report prepared by the CWPO, as well as call for the social investigation report from the probation officer or District Child Protection Unit, and consider what has been mentioned there. Then the presiding officer should take the view of the members and discuss if there is any contrary view by the member. After that, the presiding officer should pass the dispositional order in preliminary assessment. And all these steps which I have mentioned, they should find mention in the dispositional order qua preliminary assessment. Now let me come to the dispositional order after inquiry. After the JJ board have gone through all the evidences, etc., they have to pass a dispositional order as a JJ board. What should be the ingredients or components of that dispositional order? First, as I mentioned in the beginning, assigning fictitious identity, that fact should be mentioned. Then factual report containing circumstances of apprehending the child, complained by CWPO, and list of witnesses, etc., as per the record presented by the CWPO. Then the dispositional order should mention the points for determination. And the first point of determination is age on the date of commission of crime. Second, the nature of offense, whether it is a serious offense, it is a petty offense or heinous offense, because only after that you will establish your jurisdiction. And then, of course, the point for determination regarding the offense alleged to have been committed. In most of the dispositional order, determination of age and nature of offense and determination of nature of offense, it is missing. And then finally, if the juvenile take a juvenility plea in the appellate court, then the appellate court have to undertake that exercise. In fact, that exercise should be taken by the JJ board initially, so that the appellate court are not burdened with this unnecessary exercise if in appeal the juvenile take the juvenility plea. After listing these points for determination, the presiding officer should evaluate or mention about the evidence produced by the parties. Something should be mentioned about past conduct of the child, which might have been brought on record by the CWPO in social background report, as well as in the social investigation report by the probation officer. The social background report prepared by the police in Form 1 should find mention in the dispositional order and should be discussed. And the recommendation of the police officer should be either believed or should not be believed. It should be discussed in the dispositional order. Similarly, the social investigation report in Form 6 prepared by the probation officer should also be discussed. And there is a last column in that social investigation report, that is recommendation. That should also be discussed. In most of the judgments which I had the opportunity to go through, the recommendation of the SIR, of the social investigation report, is not being discussed. Then, in most of the orders, the contrary view, if taken by the member, that does not find mention. It should be mentioned and it should be discussed, because the decision of the board should be per majority. where the principal magistrate should be part of that majority. If you do not discuss that opinion or contrary opinion of the member, then that is not a good practice. And of course, after doing all these things, then you have to record your findings and your order on rehabilitation. That is the dispositional order. After dispositional order, you have to discuss the individual care plan in Form 7, which has been prepared by the probation officer, in order to see that if the child is going to a child care institution, what are his special needs there, so that you can make a special order about those special needs. Then a paragraph should be written about removal of disqualification, because mostly these children are facing difficulties when they become adult and go for some appointment in some department or go for fighting elections even. That record of theirs sent by police follow, and then they have to file applications here and there in courts, sometimes in the high courts. That opportunity should not be given to that juvenile. The order of the JJ board or the children court should have a paragraph about removal of disqualification. Then 2-3 lines about safe custody and destruction of record. Because if you will not do that, that record will pertain in the police record or in the court record, and that may become public at any date. That is again the responsibility of the presiding officer to make an order about that. And then of course, order regarding not to reveal identity of the CCL, because that is an offense under section 74, subsection 2. So if you write a line that the identity of the child should not be revealed, it will be a good dispositional order. Section 17 of the Act further entail that if, while issuing a dispositional order for a child who is not found in conflict with law, meaning thereby you are going to acquit him or you are going to release him because you do not found him to have committed the offense, then you have to assess whether the child is in need of care and protection. Because most of the time these children do not have parents or guardian. After the court have released them from the CCI, they do not have a place to go. So the board should assess whether the child deserves to be a CNCP, and if it is so, then the board should refer that child to the Child Welfare Committee so that they can pass appropriate order for rehabilitation of that child. Orders regarding CCL, section 18, Baljinder Singh have already discussed. I will skip that slide. I will not go into those details. But I would like to mention here that the Act was amended in 2015 and section 18(2) was added, which says that the board may pass additional order. And those orders may be, the child may be asked to attend school, to attend vocational training center, to attend a therapeutic center, can be prohibited from visiting a specific place, or can be ordered to undergo de-addiction program as per the requirement. These orders are generally not being passed, and this section, provisions of this section are generally ignored while passing the dispositional order. I will not go into the ingredients of social investigation report. I will only read that line where it is said recommendation regarding rehabilitation. The probation officer has to give recommendations regarding rehabilitation of the child, and while mentioning contents of the SIR, the presiding officer should discuss that recommendation, and if the presiding officer do not agree with those recommendations, should give reasons. Individual care plan, Form 7, somebody will discuss it at later stage, but that should also find mention after the dispositional order has been passed, because that will give you the idea how the child should be rehabilitated in the child care institutions. And in the child care plan, individual child care plan, the main feature which should be taken care of are child's expectations of care and protection, his health and nutritional need, emotional and psychological needs, educational and training need. And if the presiding officer comes to the conclusion that the child is in special need of any of these items, then the dispositional order should mention that, so that the child care institution provide those special needs to the child. The topic which was given to me for this presentation was, one of the subtitle was Discretion in Passing of Dispositional Order. And these discretions have been mentioned in Rule 11. It says that the JJ board can order a child to be kept in place of safety instead of observation home or special home, even if he is less than 16 years of age. It is a discretion if the board finds that the child deserves to be kept in a place of safety. He is mature enough, he may abuse the younger lot, so he can be sent to place of safety instead of observation home or special home, as the case may be. Rule 11.5. The board may order the District Child Protection Unit to arrange for counseling and community service. These facilities are generally absent. The board have the right to order the DCPU to arrange for that. Rule 11.6 says that if a child is released on probation under care of parents or guardian, then those parents and guardian may be asked to take an undertaking, to give an undertaking in Form 8 for good behavior of the child. Rule 11.7 entails that it is not necessary that in the dispositional order, the child should be awarded rehabilitation, measures, or say another word, punishment as per Section 18. No, if the court is of the opinion that the child does not deserve any punishment or any conviction order, then the child may be released by the court, by the JJ board, even on his own surety bond in Form 9. And if the child is released on probation under the supervision of a probation officer, then the periodic report should be taken in Form 10. Rule 11.10 says that if the child fails to comply with the conditions of release, then the child may be ordered to be produced before the board, so that the child may be sent to special home or the place of safety, as the case may be, for the remaining period of supervision. These are discretions. These are discretions which the presiding officer should exercise. One thing may be added here. If the CWPO or police fails to comply with provisions of the JJ Act in the best interest of the child, as a guardian of that child, the JJ board should write to the superintendent of police for initiating action against the CWPO in best interest of the child. And if the board or presiding officer come across that the child has been abused or the child has been committed an offense against him, then even the JJ board should order registration of a case to the police against those who have committed any crime against that child. So these are discretionary orders as per the facts and circumstances, as per the situations, the board may pass any order. And then, of course, removal of disqualification, destruction of record, referring the child to CWC if need be. These are some of the discretion which the presiding officer should use in the best interest of the child. Now, I come to the dispositional order by children court, because if the child has committed a heinous crime and he is above the age of 16 years, then the preliminary assessment shall be conducted whether the child should be tried as an adult or not. And if the JJ board comes to the conclusion that the child should be tried as an adult, then the proceedings will be transferred by the JJ board to the children court for conducting the further proceedings qua that child. Now I will discuss the components of dispositional orders by children court, and they are discussed in section 19, read with rule 13. Again, I have listed here the steps which the children court should follow during exercising their power as children court. Firstly, fact about transfer of the proceedings. to CC, how they came across with those proceedings, that fact should be mentioned. And if, of course, the fictitious identity has not been accorded to the child by the JJ board, then that exercise should also be taken to begin with by the children court. If appeal against the claim of juvenility is filed by the JJ board or by the opposite party, then the children court first should decide that appeal by determining the age of the child. After that, if there is any appeal against the order of the JJ board in preliminary assessment, the children court should decide that appeal. And this fact should be mentioned in the dispositional order. Thereafter, the proceedings by the children court qua trial of the CCL should be undertaken. Here also, discretion has been given to the children court that if after going through the whole record, the children court forms an opinion that despite the recommendation of the JJ board, the child should be tried as a juvenile, the children court can try or can conduct inquiry qua that juvenile, assuming the role of a JJ board, and will pass order under section 18 of the Act. It is not necessary that the recommendation in the preliminary assessment of the JJ board are binding on the CC. The children court have to form their independent opinion on the preliminary assessment. And if they come to the different conclusion that no, the child should be tried as a juvenile, then the children court is free to do that. The children court will become the JJ board, will assume the role of a JJ board, will conduct inquiry as if the child was a juvenile, and will pass order as per section 18 as if the child was a juvenile. But if the children court decides or agree with the recommendations of the JJ board in preliminary assessment, then the trial of that child shall begin as an adult as per the provisions of the CRPC. While disposing the case as JJ board, the children court shall necessarily include in the dispositional order individual care plan and follow-up action by the probation officer or the social worker. In the dispositional order, generally, this aspect is missing. Not in all orders, but in some of the orders, the individual care plan is not discussed, the follow-up action is not provided. And then, of course, the proceedings of the children court shall be in camera, and no joint trial of CCL with adult is permissible. Section 23 of the JJ Act says that. And recently, about a month back, Honorable Punjab and Haryana High Court have issued directions in a case where joint trial of a CCL with an adult was conducted by a children court. The Honorable Punjab and Haryana High Court reminded all the presiding officers that it should not happen. The procedure when the children court is acting as JJ board, they should follow or they will follow the summons case trial procedure when they are trying the CCL as a juvenile. Again, it is mentioned that the proceedings when the CC is acting as JJ board shall not be strictly adversarial in nature. And it entails that the JJ board or the children court shall use their discretion or power under section 165 of the Indian Evidence Act. They will ask questions from the child themselves and will find out the truth. When this children court decides that the child should be tried as an adult, then while conducting trial as an adult, the CC should keep in mind special need of the child, the tenets of fair trial, and child-friendly atmosphere in the court. Conducting trial of a child as an adult does not mean the child will become adult the child will remain a child. Therefore, section 19(1) clearly mentions that even if the children court is trying the child as an adult, special need of the children, tenets of fair trial, and child-friendly atmosphere requirement should be met by the children court. And the procedure which will be adopted by the children court will be as prescribed for trial by sessions court, but in a child-friendly atmosphere. And for that purpose, the children court should be given the look of a child-friendly court. And in some of the court, I have found that they have specially created a special courtroom where the proceedings qua children are conducted, and the atmosphere of that trial court is not that of the traditional trial court, but it is a child-friendly environment there. And again, the dispositional order should necessarily include the individual child care plan and the follow-up action. And till the trial is completed, the child CCL should be sent to place of safety instead of sending him to jail or to any other child care institutions. Then periodic monitoring and review. Once the child has been remanded to place of safety after holding him is guilty, then the children court has to pass an order regarding periodic monitoring and review of the progress made by the child in the place of safety. And for that purpose, the probation officer will visit the child regularly, and there is a format given. He will prepare his report in that format, and he will produce an annual report to the children court. And for that, the children court have to fix a date in the Gemini so that the file is brought back before the court to take on record that report produced by the probation officer. And that report has to be in Form 13. Again, Rule 13(8) says that even after the child has been sent to place of safety to serve the rehabilitation order, the children court may direct that the CCL shall be produced before it at least once in 3 months. The child will be called even after the final dispositional order by the CC, and the CC should be should interview the child and assess his progress, assess the facilities provided in the place of safety, and also the implementation of the ICP. And for that, the children court has to fix a date in the dispositional order itself or make an order for that. Then, once the child has completed the age of 21 years in the place of safety and the sentence awarded is yet to be over, he still have to undergo or complete his sentence. He has already completed the age of 21 years in the place of safety. Legally, he cannot stay in the place of safety. So a decision is to be taken by the children court where the child should be sent after that. And for that, the procedure or the provision of review of sentence has been prescribed in Rule 8, Sub-Rule 6 and Sub-Rule 7, as well as read with Section 20. And that review of sentence has to be mentioned in the dispositional order. The dates are to be fixed in that dispositional order. And for that purpose, it is necessary that the children court should fix the date of conviction and his date of birth, so that in the order, the date is prescribed when the child will be completing 21 years of age, so that the file may be recalled on that particular age or that particular date. For that, an order is to be made in the dispositional order accordingly. And during that period, when the children court has to decide whether the child after 21 years should be sent to children court or he should be released, the children court has to take a call. And for that purpose, they have to consider the follow-up report produced by the probation officer. And if the CC find that the child has shaped well the child has become a contributing member of the society. He has all the potential to become a useful member of the society, and he has undergone reformative changes. Instead of sending him to jail, the children court can review the sentence and can release him forthwith from the probation of a place of safety rather than sending him to jail. If the children court finds that no, the child has not reformed, then the children court may order that the child should be sent to jail. And detailed procedure about the review of sentence has been given in section 13(8) and subclause 6. In some of the orders, this procedure has not been adopted. That is review of sentence after 21 years of age. And in a mechanical way, the children are being sent to jail. When the child care institution, the place of safety in charge, seek orders where I should send the child because he has become 21 years of age and I cannot keep him there, mechanical order is generally passed that he should be sent to jail. That is not the spirit of the act. The spirit of the act is that the children court should take the exercise of review of sentence as prescribed in section 13(8) subclause in rule 13(8) subrule 6. And while taking into the review exercise, again the report produced by the probation officer has to be taken into account. After the completion of 21 years of age by the juvenile in the place of safety, if the children court comes to the conclusion that the child should not be sent to jail, he may be released, but he is in need of monitoring, he should be monitored, then under rule 13(8) subrule 7, the children court have to pass monitoring order and a monitoring authority can be appointed. That monitoring authority can be a probation officer or a child welfare officer or a case worker. They have to meet the child every fortnightly in the first 3 months and prepare a report. And then they have to submit their recommendations after 3 months to the children court. The children court then have to take a call whether the monitoring order should be taken back or further monitoring should be done, or the child should be called back and sent to jail because he has violated the conditions of release. So these are the provisions which should be undertaken by the children court, and for taking these reports on record, the children court have to order in the dispositional order different dates. Date should be fixed for taking on record these reports and making these orders. So the possible components of a dispositional order by a children court may be mention of preliminary assessment, mention of fictitious identity if not already done, detailed facts of the case, determination of claim of juvenility if any, if has not been done already, mention of appeal against the order in PA if any, and discussion on it, then discussion on determination of age of the child care of the CCL and nature of offence, justifying jurisdiction if not done already by JJ board, decision with reasons whether CCL should be tried as an adult or as a child, facts about bail proceedings and order regarding stay of CCL in place of safety, discussion about evidence produced during trial, findings of trial court proceedings or in the dispositional order as per section 18 or section 19 as the case may be, discussion on ICP and order about rehabilitation of the child, order about supervision by PO after the child has been sentenced, order about proceedings to be taken when the child will complete age of 21 years in place of safety so that the review of sentence can be done on that particular date, order regarding fixing date for taking on record the report of PO, fixing date for periodic production of the child or for evaluating his progress report, order regarding fixing date for consideration to transfer the CCL to jail or not when he completes 21 years of age in the place of safety, orders regarding removal of disqualification, destruction of record, etc. if the CC is tried as a CCL as a juvenile and not as an adult. order regarding protection of identity of the child, any other order in the best interest of the child. So these are the possible components of a dispositional order by the children court. Now, I will come or mention shortcomings noticed in dispositional order. I have the opportunity to read about 24 orders provided by the Academy. Most of those orders are as per the rules, but some shortcomings here and there have been noticed. I am mentioning those shortcomings for the benefit of the officers so that these shortcomings can be removed in their further orders. Fictitious identity not being assigned. This is the problem with most of the cases. FIR being registered, arrest being made, charge sheet being submitted by SHO under section 173, even in petty and serious offences. This is serious violation and the JJ board is accepting this violation. They are silent, they are accepting this illegality. They should mention it or they should report it or they should send a message to the SSP or to the Special Juvenile Police Unit that this is illegality. Adversarial semantics used by police as well as by the JJ board and children court. Age determination is not being done as per the procedure. In Raju versus State of Haryana, the Honorable Supreme Court of India have given an example how age should be determined. Determination of nature of offence, justifying jurisdiction. It is not being done. And now, especially after the amendment in the JJ Act on 7th of August 2021, the definition of serious offences and heinous offences has undergone a sea change. Therefore, it is to be the nature of the offence is to be determined. CRPC provisions being mentioned and used. For example, section 437A, section 173, etc. Are being mentioned in the judicial orders, whereas it should not be. Still, the SHOs are submitting charge sheet under 173 CRPC before the JJ board, which is incorrect, which is not correct. Social background report produced by the police officer or by the CWPO are not being discussed. The recommendations given by him are not being mentioned. SIR not called by the probation officer from the probation officer and the recommendation of the probation officers are not discussed if they are at variance with the opinion of the presiding officer. ICP is not called from probation officer and discussed. The recommendations are not generally discussed and order qua those recommendations made. Options other than detention mentioned under section 18 are not being used. If the child is found in conflict with law, immediately detention or probation order. These two orders I have seen. There are other options also. Those options are not being found mentioned in the dispositional order. Penal sections of JJ Act not being mentioned. Rather, penal section of IPC and substantive law like POCSO are mentioned. Whereas we all know that the charge is issued under that section under which the conviction is to be awarded. The punishment is to be awarded. And this is a common mistake. Preliminary assessment not done as per procedure. Experts are not being consulted. And if consulted, their opinion are not being discussed. And if the opinion of that expert is not being agreed upon by the JJ board, then reasons are not given. Proper terminology not being used in the dispositional order. For example, juvenile officer is written in place of CWPO. Juveniles are written in place of CCL. Social report is written in place of social background report. I never found a mention of use of section 165 Indian Evidence Act in any of the dispositional order. That is a very important aspect. The presiding officer should himself question the child and should himself record the answer given by that child. Presumption of guilt under section 29 of POCSO entertained against juvenile, whereas JJ Act, the first principle prescribed presumption of innocent, and section 1 subsection 4 of the JJ Act says that the provisions of this act will prevail over provisions of any other law for the time being in force. Proceedings under section 82 and 83 CRPC undertaken against absconding CCL. Criminal proceedings are even entertained against runaway children. No mention of age on the date of dispositional order to determine whether the child should be sent to place of safety or jail in heinous offences. Fine being imposed on CCL without assessing whether he is eligible to work as per the labor laws and earn wages. And if he is not, then who will pay that fine? JJ Board sentencing for the period undergone in custody in observation home and jail during inquiry. This is not the prescribed sentence in section 18. Rather, if the presiding officer is of the opinion that enough is enough, the child should be released, he should release the child on his personal bond, rather than recording that the sentence undergone shall be sufficient punishment for him. Awarding sentence by JJ Board, both under section 377 IPC and section 6 POCSO. Under both the sections, the punishment was awarded separately and the appeal was upheld even by the children court. Preliminary assessment not done in first 3 months, and JJ Board started trying the heinous offence without preliminary assessment. Recommendations of probation officer in SIR is not considered. Contrary view of members not being discussed in the dispositional order. Final dispositional order not signed by any of the private members. It is signed in some of the cases only by the magistrate, whereas it is mandatory that 2 members should sign that final dispositional order. Section 18(3) empowers JJ Board to transfer proceedings to children court directly. Still, some of the JJ Board have referred the matter to district and session judge for transferring the case to children court under supervision, review, monitoring orders by children court and sending the convict to jail after 21 years. This is a most common shortcoming. Order regarding removal of disqualification, destruction, safe custody of record and protection of identity are also not found in some of the orders. I sum up by again repeating those lines that criminal proceedings against juvenile under JJ Act is not another trial. It is a collective rehabilitation exercise in which the private members, the probation officer, the case workers, the NGOs, the presiding officer, all have collective responsibility. Therefore, it is request in the best interest of the child that the presiding officer should shun the role of or robe of a judge and be a foster parent. I stop here and now I may answer any query if it is there. The academy has forwarded me 5 questions which were to be asked by various participants. If you allow, I can discuss those questions and then we can take further queries or further questions. Presentation में आगे हो रहा है. Yes, any observation, any view, any question? Somebody can respond if I am audible. Yes, somebody can respond if I am audible.
Yes, sir, you are audible. You're audible, sir. Probably the PPT itself, the lecture itself was so elaborate that I doubt that there will be any doubt in the mind of the participants. But still, you can elicit the queries, if any, from the participants. But you are audible, sir.
Please, thank you, sir. The academy forwarded me 5 questions received from the participant. I will in short answer that. The first query was that in cases where juvenile refused to issue juvenile failed to appear before the presiding officer despite issue of arrest warrant, and police want arrest warrant, whereas the magistrate is not in a position to issue arrest warrant. How to go about to procure presence of CCL? Police demand non-bailable warrant. And the answer is in section 26 and rule 10.3 and 10.4. Section 26 deal with CCL who have run away from observation home, from special home, or from police custody, or from protection for place of safety. And it says that any police officer may take charge of such a CCL. If a child has failed to appear before the court after he has been released on bail, then rule 10.3 and 10.4 says that the JJ board may issue direction to the CWPO and the SHO to produce the child. And if they fails to do so, the JJ board shall pass appropriate order under section 26. What can be that order? I have written that order, and you can consider it for incorporating in your exercise. Order under rule 10.4. The order can be as under X, a CCL who is facing inquiry number itne under JJ Act has failed to appear before the board from itne onwards till date. Even the CWPO and SHO of PS itne have failed to produce him despite directions from this board under rule 10.3. Therefore, exercising powers under rule 10.4 of the JJ rules 2016, orders are issued to treat X as a runaway child under section 26 of the JJ Act. Now, any police officer may take charge of X as per the law. The CWPO and SHO PS itne are further directed to initiate legal proceedings qua X as per the law. And most of the police officers are ignorant what exercise they should take once the court have directed that the action should be taken to trace the child. In Bachpan Bachao Andolan versus Union of India, civil writ petition number 75 of 2012, the Honorable Supreme Court of India ordered that a runaway child or a missing child, FIR should be registered. Police was not registering FIR earlier. They were only writing daily diary entry. So this Honorable Supreme Court ordered that FIR should be registered, and now police have started registering FIR under section 346. That is illegal confinement, and trace that child. And several states have issued SOP. I know about Haryana. An SOP was issued on 19th of December 2014. Even under my own signature, I issued it. So FIR should be registered by the police, and they should make all efforts to trace that child. So this is the exercise which the JJ board can order the police to undertake. Is it clear? Can I go on to the second question?
Yes, sir. Please move ahead. Yes, sir.
How to appreciate evidence in heinous crime? This was the second question asked. In heinous crime, the children court, I have given in detail how they have to undertake the proceedings. They will appreciate if the child is tried as an adult. The children court will appreciate the evidence as if he was an adult under the children court will deal with as if he was an adult, except the fact that death penalty cannot be awarded to the child and life imprisonment without the possibility of release cannot be awarded to the child. The third question, procedure to be followed where juvenile has become major and has been arrested in another case and is lodged in jail, where he should be confined after disposal of the case. It is a very important question and practical question. Normally, there can be two situations. The juvenile is in between the age of 18 to 21. And second, the juvenile has crossed the age of 21. If the juvenile has crossed the age of 21, then he will be lodged in jail if he is already in jail. But the trial will be conducted as per the provisions of JJ Act. His production warrant will be issued. He will be called for the proceedings. And as per JJ Act, the orders will be issued. But he will be confined or remain confined in jail. If the child is in between 18 to 21 years, and during that period he committed some crime and is lodged in jail, then the proceedings will be undertaken as per the JJ Act, but it is the discretion of the JJ board whether they should send back that child to jail or they should send that child to place of safety. Because section 1, subsection 4 of the JJ Act says that the provisions of this act will prevail over provisions of any other law for the time being in force. Is it clear?
Sir, I would like to probably bring it to your kind notice that one part of the question is that suppose when the person is a child, that is below 18 years of age, he commits an offense, obviously JJ Act will take care of him. Now he's already facing one case before the JJ board, and after attaining the age of 18 years, he again gets involved in some offense. So probably to my mind, when during adulthood he commits any other offense, then the general law would be taking care of that. Instead of again, he can't be pushed back into the JJ Act. If
during the commission of the crime, he was a juvenile, he should be treated as per the Juvenile Justice Act.
Yes, sir.
No matter he has committed 3 crime, 4 crime or 5 crime.
Yes,
it is the age which will determine whether he should be tried as a child or under the provisions of JJ Act or not.
So the other part of the question probably which I can read from your slide is that if the juvenile, when he was juvenile, he's already facing in an inquiry before the JJ board, but during the pendency of inquiry, he becomes adult. Let us say he becomes 19 years of age. At that time, he commits another fresh offense. So question is, regarding this new offense, what is to be done?
Regarding this new offense, he will be tried as per CRPC because he was not juvenile at that point of time.
Yes, sir. Yes, sir.
But in the first case, he will be tried as a juvenile.
Yes, sir. Thank you.
And it is the discretion of the JJ board whether he should be lodged in place of safety or he allow the person to be continued in jail. Because up to the age of 21 years, the child can remain in place of safety.
Please, sir. Thank you.
Fourth question. In NDPS case, when the presiding officer is on leave, where should the juvenile be produced for preparing the inventory in NDPS that case? Should he be produced before the Lakamaji magistrate or before the member? And the answer is before the member, because section 7.3 and subsection 7.3, rule 9.5 and 9.7 says a child can be produced before a single member of the board and a single member can pass an order. Such an order shall need ratification by the board in the next meeting. No order passed by the board shall be invalid by the reason only for absence of any member. Only the presence of 2 members are required, including the principal magistrate, for final disposition. And to explain my point further, I put up this slide before you. Section 1.4 of the JJ Act. It says the provision of this act shall have overriding effect over any other law for the time being in force relating to all cases involving apprehension, detention, prosecution, penalty, or sentence. Is it clear?
Yes, sir.
So these were the questions which I received from the academy. If still there is some question, I may reply that.
If any of the participant has any question for Dr. K.P. Singh, please come forward. I think so, sir. There's no question from the participant. Probably it was so elaborate and so well tailored that it took into its ambit all the possible questions which could come to the mind of the participant. And I thank you also being a co-speaker in this lecture and taking over my burden, I would say, and dealing with this part of the this aspects of the JJ Act. Thank you so much, sir. Thank you so much.
So thank you, Baljinder. it was a privilege and pleasure as well as an honor to interact with the participant in the presence of Honorable Mr. Justice Augustine George Masih, sir. Good afternoon, sir. It was really a blessing for me and I'm really honored. So thank you very much. I will be having another session tomorrow from 10 to 11 on police inquiries and police investigation, etc. Thank you very much.
I would just like to thank Dr. K.P. Singh for the elaborate, detailed presentation which he has given. I think there being no questions from the other side obviously makes everything clear, that you were so clear and elaborate. Everything was so beautifully put up by you. None could actually find any difficulty in understanding what you had projected before them. Thank you very much in any case, Dr. Saab. And we are looking forward for the next session tomorrow morning.
Thank you very much, sir, and grateful.